All right, let's get started. Hello, everyone, and welcome to the 8th webinar of the Grievance Redress and Accountability Mechanism Partnership. I'm Peter Carlson, the Communications Associate at the Independent Redress Mechanism. Before we begin, I'd like to remind you of a few administrative matters. There is interpretation available in both French and Spanish. So if you go down and click on More, there is an interpretation option. And if you click on that, then you can toggle between English, French, and Spanish. While we ask you to mute your microphones when you're not talking, we do invite you to keep your video on so that you can get to know the other members of the Grand Partnership. For the speakers and for those who have questions during the Q&A session at the end, to help the interpreters be able to listen as best as possible, if you do take the floor, please make sure to speak slowly and preferably with a headset. And then lastly, just so that everyone is aware, the webinar is being recorded and we will be using parts of this for communications after the event. And there will be a part of it that's recorded that we'll share for those that are not able to attend. So now our webinar today will focus on flexible sequencing and hybrid models of mediation and compliance for handling complaints. When a complaint is filed, many of our organizations follow a sequential process. First, we start with mediation, and if that fails, we move on to compliance review or investigation phase. However, our question for today is, can other flexible or hybrid approaches be used to handle complaints? Next slide, please. Now, today's webinar topic comes about for two main reasons. First, there is a group of CSOs that recently published this good policy paper, guiding practice from the policies of independent accountability mechanisms. And this paper is supposed to act as a roadmap to guide the development of new IAMs or international accountability mechanisms and the revision of existing IAM policies. It examines the policy provisions currently in place at IAMs from the perspective of communities using them to seek redress for environmental and social harm from internationally financed projects, and identifies the most effective provisions as examples for other IAMs to follow. Now, within this paper, recommendation 36 focuses specifically on this question of sequencing. As you can see here, the text, complainants should be allowed to choose dispute resolution, compliance review, or both, and their sequence. Considering the intrinsic differences between the functions of the mechanism, complainants should have the right to choose which ones may best serve them and in what sequence. The mechanism should be empowered to conduct dispute resolution and compliance review contemporaneously or sequentially as appropriate and as requested by the complainants. So we see here already a desire from CSOs for accountability mechanisms to have a flexible approach when working with complainants. So that was the first kind of reason that this topic came about. And the second is at the IRM, we wanted to share our experience that we are undergoing and have underwent about a current case that used parallel processing. And Paco will talk more about this in just a bit. So I'd like to now introduce our panelists for today's webinar. First, we have Manuela Grosu, who is a managing associate and lead attorney at law at the Dispute Resolution Practice Group of KPMG in Hungary. She's a lecturer at Itvas Loránd University, Faculty of Law in Hungary, where she also holds a PhD and is a trained mediator. She studied in Hungary, Turkey, and Austria, and her doctoral research focused on international commercial arbitration and mediation and included the interaction between non-binding alternative dispute resolution methods and arbitration in international commercial disputes with an emphasis on hybrid procedures. And she now regularly publishes on various alternative dispute resolution related topics and participates in mediation training related activities. Our second panelist is Paco Jimenez Salinas, who's the Compliance and Dispute Resolution Specialist at the IRM. He was born in Spain and is a lawyer by profession who specialized in alternative dispute resolution with a focus in mediation. He has undertaken postgraduate studies in the fields of conflict resolution at the University of Barcelona, political analysis at the Mexican University CIDE, and community company mediation at the University of Cape Town. Third, we have David Fairman, who is a senior mediator at the Consensus Building Institute and associate director of the MIT Harvard Public Disputes Program. He holds a PhD in political science from MIT and a bachelor's summa cum laude from Harvard. For 34 years, he's built consensus and enhanced collaboration capacity on complex public and organizational issues internationally and in the US. And our last panelist is Scott Adams, who's a senior dispute resolution officer at the World Bank Accountability Mechanism. He has over 27 years of experience, both domestically and internationally, in providing dispute resolution, management consulting, and training services. He received his bachelor's in political science and Russian from Emory University and has an LLM in public international law from Leiden University in the Netherlands. He is now on development assignment with the World Bank Accountability Mechanism in partnership with the Multilateral Investment Guarantee Agency, Independent Accountability Mechanism, the Office of the Compliance Advisor Ombudsman, where he has served as Senior Specialist Ombudsman with the Dispute Resolution Team. Next slide, please. So moving to today's agenda, we will first have Paco, who will give a brief overview of alternative dispute resolution processes and linkages between arbitration and compliance review. We'll then have Manuela present her recent research around hybrid models in mediation and arbitration in commercial disputes. Now, I just want to preface this by saying that you might be wondering how the complaint process in a commercial or private sector setting is relevant for the GRAM community. And I think we wanted to mention first that we are mindful of the differences and objectives and processes between these two groups, but we're also aware of the potential similarities that our community can take from this research, which we'll explore during the webinar. Next, Paco will then present an overview of the IRM's ongoing case where we used flexible mediation and investigation approaches. And then following these presentations, we'll have a panel discussion with both David and Scott, and they'll explore a series of questions that will help us tie together some of the applicability of these approaches for grievance redress and accountability mechanisms. And we will have time at the end for a Q&A session where you'll be able to ask questions or provide additional inputs. So with that, let's get started. If we can get Paco's first presentation online, I'll hand it over to Paco, who will give an overview of alternative dispute resolution processes.
Okay, thank you very much, Peter. Yes, I will now briefly present on general concepts about ADR. Many of you are already acquainted with the term and the different types of processes and its features, but we thought it would be good to refresh some of these concepts. Also because today we have invited an expert on dispute resolution that comes from applying these concepts to a completely different context. And maybe a first very reasonable question one could pose to the data agenda, as Peter indicated, is wondering what is the difference and what is different and what is similar in dispute resolution options in the context of commercial disputes and the context of accountability. So in order to help to respond that question is why we have adjusted the agenda, and I will present on the basic theoretical concepts and considerations on ADR. And I will also reflect on potential linkages between arbitration and compliance review, and whether those, and then you can decide whether those are importable to our world. If I will now highlight some commonalities, then David Furman at the end might also highlight some differences. So as I said, providing this initial conceptual foundation will help you decide what can be extracted and imported from the solutions that are being applied to solving disputes in other potential very innovative contexts. Next slide, please. So ADR has become the familiar label for designating a range of dispute resolution processes other than court litigation. These other dispute resolution processes can be categorized in two categories based on the role of the neutral in the processes. Those two categories are adjudicative processes and non-adjudicative processes. Adjudicative processes are processes where the neutral makes a final and binding decision or determination. Let's focus here on the word final now. The non-adjudicative processes is where the neutral has no power over the outcome of the process, either because it makes a non-binding proposal to the parties that they can accept or reject. So this recommendation is addressed to the parties, not to the board, not to the institution. It's only addressed to the parties that they can accept or reject. And also because the role of the neutral in other cases might be limited to assisting the parties in reaching an agreement, to facilitating a conversation. From the parties' perspectives, what differentiates adjudicatives from non-adjudicative ADRs is the level of control parties keep on the outcome of the process. In both arbitration and compliance, parties do not have control over the outcome of the process. That happens in compliance as well, as I said, because the decision of the neutral is final, whether binding or not, depending on its adoption by the institution. Meanwhile, as I said in problem solving, parties retain full control over the outcome. It might be an outcome that they are not so completely satisfied with. It can be a trade-off, but they have the power to decide whether they accept that or not. Next slide, please. I will now briefly address the question on what are the factors that parties should consider, some of the factors that parties could consider when choosing between adjudicative ADR and non-adjudicative ADRs. In our world, this question is equivalent to deciding between compliance and problem solving. In choosing between adjudicative or non-adjudicative processes, there are several factors the parties might want to consider. First, what is their goal and priority? Is the priority exclusively getting redress for resolving their situation? If this is the case, then this goal is usually better served by retaining control on the outcome of the process. Therefore, mediation or problem solving could be the right initial choice. If the priority is triggering institutional learning or institutional reform or setting a precedent, then compliance and or arbitration, depending on the context, serves this goal better or serves its goal. So in deciding how much control needs in a particular process, they also might want to consider the following. So what are the odds that arbitration or compliance review will endorse the allegations of harms and demands of redress? And only in the case of compliance, what are the odds, the additional odds, that the institution then will adopt the compliance review recommendations on harm or redress? A potential approach could be that deciding that if the combination of these probabilities is below or way below 50%, then parties should consider mediation as their first choice, especially because compliance remains an open possibility. So in conclusion, arbitration and compliance differ in many ways, but also share many commonalities. The factors that parties need to consider when choosing between adjudicative and non-adjudicative processes are quite similar. Therefore, exploring how those two categories of processes are combined or could be combined in the very innovative world of commercial dispute resolution, as Dr. Grosso will now present, we thought could be highly beneficial for the conversation of flexible sequencing in the world of accountability of IFIs. So now with that, over to you, Manuel.
Thank you very much. Good afternoon, good morning, good evening. I know that we are located in different time zones. It's my honor to be there. Thank you for the invitation. As Peter mentioned, I conducted a research because my research interest is combining mediation with arbitration and mediation in general. So when I will reflect on that based on my research, based on my experience, actually I'm reflecting on conducting interviews. It is approximately 100 interviews. It means that I was talking to mediators, arbitrators, legal counsels, and attorneys. So this is the experience that I collected, and the advantage and disadvantage I will reflect on pretty much is based on what I was learning from this empirical research and of course from already existing scholarly writings. So please, next slide. Then I would shortly demonstrate first that we will short introduction. Then very briefly, I will reflect on different process sequences. This will be a very descriptive part of my presentation. Then we will compare arbitration and mediation to have a very quick overview to decide whether it's compatible or not to combine these procedures. Then we will address certain particular hybrid procedures. We can challenge the idea whether they are indeed hybrid procedures or only kind of process sequences. I will briefly reflect on how we get there. Actually, this is something that maybe I should have started the discussion, but intentionally I leave it for the end of our presentation, how we get in a situation of combining procedures, and then a few closing remarks. Next slide, please. Then next slide again, please. So I'm very thankful that actually Paco already provided you with a very important introduction, how to make distinction between compliance review and arbitration, and of course, how can something from a business community, business dispute resolution setting actually useful. Let me step back a little bit and talk about what's the difference between conflict of dispute. This is of course really common sense, but you will understand why I would like to talk about it. Conflict, of course, is an underlying controversy, inconvenience, and discrepancy. We all know that. Why dispute, and we say dispute resolution, is something, a disagreement on a point of law, and maybe from your perspective is more important, a point of fact. So, of course, when we have a dispute, we already know there is a conflict because disputes form part of the conflict. But when we see only the dispute, this is only the top of the iceberg. So what does this should do, or whether it has something to tell in terms of the combination? Because mediation at least has the promise or the intention to resolve the conflict, not only the dispute. So when we are already in an adjudicative process, maybe the combination SVVC can help us to focus not only on the dispute resolution, but also on the conflict resolution and to dig inside this aspect. And even in dispute resolution, I'm talking about commercial disputes or other different sectors. So mediation is a problem solving. Even if I talk about commercial dispute resolution, is the same. It's very important that it's interest-based and future-oriented. Maybe sometimes mediation is blamed that it's too much future orientation and problem solving. So that's why sometimes we need to see when we talk about combination that sometimes people have the demand to have some past orientation also that we have in arbitration. So not only arbitration is not only important because of decision making, but it allows the parties to reflect on and understand and explore past happenings in terms of facts, law, and different circumstances. We need a competitive attitude, of course, because we will focus on a very win-lose outcome. And in order to gain that, of course, we need to be, even if we don't need to be, in most of the cases, this is what's happening, a competitive attitude and focus on their positions. Since I will reflect on the same neutral setting also, combining procedures with the same neutral, what I mean under that, just to make clear, we have a mediator as a facilitator, like an advisor, who has the communication, who builds bridges between the parties, and an arbitrator as a decision maker. Of course, these are a very general setting, but we can be more specific. It doesn't mean that sometimes the arbitrator can be very collaborative, can help in reaching a settlement, and we can see mediators and mediations who are very happy and open to give a proposal, which is more than being facilitative, but keeping it like that, these are the main distinctions. Since Paco already mentioned the distinction about arbitration and also the similarities between arbitration and compliance review, then I would not talk about it particularly how commercial dispute resolution experience can build on in accountability mechanisms that you have a huge experience with. Next slide, please. Then we will move on the different process sequences. So let's the next one. First, sequential procedures, Med-Arb and Arb-Med. Sequential, this is something that I know is common practice. So that's why I will not devote much time to talk about first mediate, and if the mediation fails, then it is followed by arbitration. What can be an interesting asset to this, to think about how to do a sequential process with the same neutral. So the mediator turns to be the arbitrator. When we analyze the pros and cons, I will get back to this later. The other option for a sequential procedure can be ARB-MED. It's very interesting because now we would like to move for a competitive and more narrow dispute resolution setting to a rather broader one. So the neutral first serves as an arbitrator and then mediates. This would be also a same neutral setting. So we can imagine that the arbitrator will hear the parties, the presentations on the facts, on the legal issues, and then renders the decision. But it's very important that this decision wouldn't be communicated to the parties, wouldn't be announced, but put in an envelope. Let's imagine, to give a practical background, so this is not announced, but the parties can see that the arbitrator was ready and able to render the decision and reach of outcomes, put rather in this context, to close the dispute. So put it aside and then give an opportunity to the parties to settle the dispute. And if to have a time frame is very important. And if there is no settlement during this predetermined time, of course it can happen, then the decision will be announced. So we ensure that there will be finality, there will be an outcome, certainty of outcome at the end, but still give a final opportunity to the parties to take back the ownership of the dispute resolution. A variation of this can be, I wouldn't say frankly that this is really a combination, but from a practical point of view can be useful. Variation that mediation just helps to implement the decision. So its mediation is not really combining, definitely not integrating, but saying that we have the outcome. It can be an award, can be a report or judgment, and then let's move on with the mediation in order to ensure that we can live with this outcome in an efficient way and implement it into practice in accordance in what was, of course, written down by the arbitrator or the individual who was serving in an adjudicative role. Please, the next slide. Parallel procedures. Here, of course, I made distinction between simultaneous and really purely independent. What I mean under that? That we have, for example, mediation and arbitration in parallel. They are independent totally, and the neutrals not even know each other. So we really keep them separate. While working on our own outcome, let's assume in mediation, with a mediator, with a totally different individual or group of individuals, there we have an arbitration. So it's very important, we will see that in this case there will be no exchange of information between the mediators and arbitration, and the parties would not share their experience that we have in these procedures. An example, let's give a practical example for that. It's not really parallel, but almost, when you appoint a mediator from the outset, but you put the mediator, let's say, put in this way, in reserve. So the mediator will be available during the pendency of the arbitration. And in any moment during the arbitration, a party think that the mediator can help in negotiating a settlement. They already have the mediator appointed. They already have someone who could help them in this. Maybe this is not from the outset, but I would say that this is still parallel. And this is something that I learned from the interviews. It can be put the parallel process in this way, but to ensure that somebody can help in the course of the arbitration when you realize that there are some issues better to mediate. I will get back to this later. There are another variation of the parallel procedures. It is simultaneous, but frankly, not really independent, in fact. But I mean under that. That parties still appoint separate neutrals simultaneously, or maybe later, but they are aware of one another. So typically, they figure out that the arbitrator would figure out that there are some issues better to mediation of the parties. It's a parties initiative. That some issues are better to negotiate, and they kind of carve out to mediation these issues. And an alternative to this can be a shadow mediation, where you have the mediator who almost there talk to the neutral, talk to the parties, they know each other, they know that there are parallel procedures going on, and try to work almost as a team And we will see what are the challenges with this kind of very collaborative hybrid procedure. Please, next slide. So then we will move to the integrated ARB-Med-ARB. In another way, we can say that this is the mediation window when there is an ongoing arbitration. So the arbitration, when we are, let's put in this way, when we are already in an adjudicative process going on. We don't know that it started or it's going on maybe for a year or for months, but let's say that it's definitely already started and the other process is initiated in the course of this procedure, so we integrated. But I'm saying you maybe you have the question that it's like parallel. I would say it's not parallel because the process we started first, it's very important, that would be suspended. So no procedural activity in order to give room and give opportunity for the other procedure to move on. As we will see, it can be also a separate or a same neutral process sequence. So the process is initiated first, we'll continue. That's what's going to happen, right? So we have the mediation fails. The mediation then resumes. We need to figure out and decide that there was no settlement. Then the other procedure will move on. Otherwise, the parties have a settlement. What's the benefit? Definitely, there will be a certainty of outcome because we are already in an adjudicative setting, as Paco mentioned, which would ensure us to have an outcome at the end. Please move on our next slide. And this is the same or separate neutral dilemma. Of course, this is a dilemma because it has many advantages, but of course, this is a very risky process if it can be done at all because of policy reasons, because of legal provisions. Now, very basic issues I raise and some concerns, but of course, with the same neutral dispute resolution has many complicated legal and I think very practical difficulties also. First of all, very important for us to understand this can happen even if as neutrals we really like the idea, we think that we are able and capable of doing both roles, that this is something that can be done only with the agreement of the parties involved. Saying agreement, I mean informed consent and good understanding of the situation. Same individual serves in both roles, as I mentioned. A challenge can be, it's very difficult to find such a neutral. Based on my interview research, only a limited number of neutrals, and I was conducting 100 interviews from all over the world with neutrals, mediators, arbitrators involved in commercial disputes with huge experience and primarily serving as mediators and arbitrators. That only a limited number of neutrals had actually experience with combining roles and doing it themselves. So you need to have a process knowledge, you need to know what's mediation, and of course you need to have a subject matter expertise when we go to arbitration and legal also background and knowledge. But let's say in this way, process knowledge, substantive knowledge, and one neutral, and the willingness to do it, right? It's very important. Not just the capacity, but also the openness to do it. So let's move on to our next topic, yes, comparing arbitration as mediation. Very quick overview, because I think Paco indirectly, but for me it was very useful, already actually reflected on many of these. So we have the goals, very important, decision and settlement, win, lose, and win-win, and it supports the combination. You might think why it supports the combination, and let's see the last row, final decision again, and settlement agreement. How can this be compatible? They are very different dynamics and very different goals still. I would claim that the objective findings, the objective findings of an adjudicative process, in my case, arbitration, can be a very good mix with an exploring very subjective interest of mediation. Of course, by assumption in this case, the mediation is not serving like a standalone individual process, but rather a complement to arbitration, so helps arbitration in this sense. And in this sense, I think it's possible that the support is indeed there, and this would support the combination. Very important, both procedures are confidential. Impartiality, independence are very important. Why? It's always when we combine procedures, it helps a combination if the procedures involved share the same fundamental values, process values, and requirements. And confidentiality, independence, and impartiality of the neutral are really critical issues, as we will see. And when we combine the roles, we might have some issues and problems with confidentiality, as I will touch upon this later. In terms of formality, I will not cover all these issues on this slide, but I would like to talk about formality of the process. Of course, arbitration is more formal. In general, adjudicative procedures are more formal, but we now have to think about when it's more informal, but mediation is also very good structured and following a logical sequence of procedures. Finally, what I would like to cover from this, of course, the voluntariness is very important, the qualification. So there are no special requirements. However, we all know that if we would like to have we would like to have a combination of the procedures, even if we don't have same neutrals, we need to have dispute resolution experts involved to understand the differences between the procedures and how they can interact with each other in order to create value for the parties instead of making the process even more complicated. So let's please move on the next slide. And this will be now that you move on the pros and cons a little bit into the details. So Med-Arb is a sequential same neutral procedure. Of course, an advantage, a pro would be in a same neutral setting that the fact-finding and the education, the neutral is already over. So we don't need to repeat ourselves. This has the assumption, and my research actually challenged this assumption, that individuals, disputants are telling the same set of information, behave the same in an adjudicative and in a non-adjudicative process. Although this is not always the situation. The way the information and how you interact in a mediation, it can be very different from that of in an arbitration. But in an arbitration, you would like to convince the arbitrator. In mediation, you would like to convince the other party. I'm not saying that this is not a real advantage. It is, but we need to think about that the delivery of information can be very different. And I think this is not only for commercial dispute resolution. We can, of course, save time and cost, definitely, narrow down the issues because we already had a mediation which helps that in this. So even if the mediation, of course, fails and we move on arbitration, we still have a more focused parties, and maybe we were managed to reach settlement of certain issues. So it indeed narrowed down the issues for arbitration. It can foster settlement, even if not, of course, because the parties under a pressure that the mediator will become an arbitrator and they rather settle in the mediation. If we move on arbitration, we can expect that the parties will be more open to the decision of the arbitrator, more acceptable because they become more reasonable. The cons, I tell there because this is something that I will not tell the other process sequences. Confidentiality courses with same neutral settings is always a critical point. You learn information in one process and what's going to happen with this information in the next process. Should I tell to the parties, should I reveal only material information that I think would be material for the decision making, and how this would influence me as a decision maker, whether my impartiality, compromising the impartiality of the decision maker is a huge danger here. Of course, you need to separate in your brain the information that you learned in one process, you cannot bring to the other one, of course, without the express consent of the parties. If they give the consent, it's of course different. And again, you need to find a fabulous neutral, and it's very difficult, who is qualified to do both procedures. Please move on the next process. Med-Arb is a parallel process, very briefly. So it pros, of course, that it's carving out issues for the mediation, which are not actually appropriate for the arbitration. So the arbitrator doesn't even want to see these issues anymore, saying this is not legal issues, but it's better for settlement purposes. This is not on. This is maybe about relationship issues in business setting. We also have this. So it's better to carve out and to resolve in mediation. No danger of influencing the other process, right? Because these processes are going parallel and with different neutrals. Shadow mediator, we already talked about that, working together, the different kinds of neutrals, and the mediator would maybe join the arbitration process and kind of listen to the fact finding. And if mediation indeed takes place, already knowledgeable about many issues in order to have the parties with certain issues to be resolved. Of course, disadvantage, it's very expensive. So we have two procedures. Can be contradictory outcome, but frankly, when we reach an outcome in one of the procedures, and the other one obviously would terminate, but still the idea that we work towards contradictory settings is there. It can be very confusing for the parties if they are not satisfied, not prepared enough to understand how these processes works, and we need again a very experienced neutrals to do so. Please, the next slide. ARB-MED-ARB. So this is the mediation window. In terms of the pros, it's very important that this would ensure finality, the one that Paco also mentioned, ensure that there will be an outcome because we are in an adjudicative setting. This can be very efficient, right? Because we are already in this adjudicative setting. We know that if we don't settle, and this can be actually an advantage and disadvantage at the same time. There's a huge debate around that. This is actually what I experienced in my interviews, that this is very solution-oriented mediation. If this happens, parties are really cooperative because they don't want the arbitration to resume. They don't want to have a final outcome imposed on them. But at the same time, the mediation will be really under pressure. So it's not about investigating and figuring out creative outcomes because you are really solution-focused. It can have to preserve the relationship in long-term relationships. It's very important. It's like a teamwork again. It's a social learning that you should rather resolve your dispute yourself and take ownership of the outcome instead of relying on a third-party decision maker. In practice, sometimes only sub-issues can be resolved in mediation, so the arbitration indeed would move on. But it's useful because it was good to narrow down at least the dispute resolution process. The same neutral dilemma, I don't want to repeat myself, just those which I haven't mentioned yet. Of course, when we have an integrated process, it's easy to switch back if we have the same neutral, both from a legal and of course, both from a practical point of view. Saving time and cost, yeah, I mean, the mediation successful, yes. Otherwise, we need to acknowledge that we generated more time and cost, frankly, and because otherwise the arbitration could have produced an outcome earlier. And again, we had the problem in impartiality and confidentiality, which was already mentioned. Please move on the next slide. So,
hi, Manuela. Sorry to interrupt. If you could just slow down a little bit for the interpreters,
yes, sure,
it'll help with their interpreting to the other languages.
That I'm running out of time. That yes, Peter. Sorry, I will slow
no
down.
Worries.
Thank you.
Thank you.
Of course. So the next process sequence is ARB-MED as a sequential process. First of all, the big question: how realistic it is in business setting, and I really wonder how this will be in your world in this an accountability mechanism, that once we are committed into an adjudicative process and almost going all over, let's say, we are almost there to have the final report, in my case, to have the arbiter award, to have an outcome. How realistic it is that now there is a last chance to settle. It's very interesting that research shows that parties really in a psychological pressure now, almost fearing of what's going to be the outcome and realizing what the adjudicative process will go on. They are reading in the minds of the arbitrator, understanding the questions, see the arguments, see the evidence, say that this is a last chance for us to settle, the last moment. And under this pressure, after wasting time and money, and yes, a lot of time and money, especially in a business dispute resolution setting, they still decide to settle the dispute instead of gaining the arbitral award. Take back, it's like we can say, take back the ownership of dispute resolution that was already delegated to arbitral tribunal. So a reasonable attitude. I was telling you that in an ARB-MED-ARB, the parties are very reasonable in mediation. Now here, they are even more reasonable, right? And very efficient and focused. Of course, if it's not producing a settlement, again, we generated more time and cost. There is a focus on solving the dispute and reach a settlement, definitely. And this is a mediation under pressure that I mentioned to you can be very challenging. For this can be an example. Let's tell you that when the arbitrator can say that, well, I am able to and capable of rendering a decision. I already have it. I can do it. It stands for ARB-MED-ARB and ARB-MED also. But I would propose, why not to think about mediation? He would not say, this is what I was learning from my research, I would like to be a mediator. Would say, haven't you thought about reaching a settlement? Because the facts are really confusing. This is not clear what was going on. Maybe this will be a zero-sum game, 100-0, which means that one party will really lose. Maybe this is not the fair outcome. Let's consider what would be the fair outcome, taking in consideration other factors, business relationships. So, of course, you need to be a very brave decision maker to do this, to raise it, because your main role is to render a decision, not to bring peace and the settlement among the parties. But this is what I was learning, that this is something that can happen. So this can be an initiative of the decision maker, let's say like that. But of course, it can be also coming from the parties, reading in what's going on in the adjudicative part. In the same, this is a same neutral setting rather. Since I mentioned to you, it's an envelope, we have the decision there, and the decision is not announced. And the same neutral will do the mediation. But there is no ARB-MED-ARB dilemma with the confidentiality issues and impartiality, because no decision-making activity later. So the ethical dilemma, I learned something in mediation, and I would think about, oh, maybe I should have written a different award. Maybe my award is not as good as I thought. But just now for process design, I'm not getting into the legal issues. We would say you can change your decision. You announce it, or the parties decide, parties reach a settlement. So the parties here are really trying to convince not the mediator, like in an ARB-MED-ARB setting, but try to convince each other. This is a huge difference when we integrate the process or when we have ARB-MED as a sequential one. And then my last topic, as far as I remember, before the closing remarks, please go to the next slide. Of course, this is something that I should have started with. How do we get there, right? We were talking about combinations, pros and cons, be collaborative, be competitive, positions, interests, win-lose, but how can we get in such a process sequence at all? So when to initiate it? Of course, we say in general to mediation, the earlier, the better. This is almost common sense. Not always. Sometimes we need to start an adjudicative process. This is what I was learning. It was one of my findings in the research. We need to start an adjudicative decision-making oriented process, like an eye-opener. And this can be a moment for the parties to consider first time or to reconsider to have a non-adjudicative process. In our case, we use the term now mediation. So yes, the earlier the better, because this is the way how you save time and money, but this is not always the case. Sometimes you need to fight first, put in a very simple way, before you compromise on certain issues. Of course, it depends on the parties, depends on the many issues and things when to initiate it. As we can see now, even in an ARB-MED, it's never too late. And it's very important. It's a bad reason, this is my opinion, to say that no combination of procedures, because mediation is just for the weak negotiators, and it's already too late. When I am in an adversarial setting, it's too late. It's never too late if it makes sense. Who should initiate it? Very important. The parties. In an ideal world, it would be the parties. These are sophisticated, they are reasonable, and they just know that this is the moment to have a combined procedure right from the outset. Or later on, they can propose to have a mediation to consider non-binding dispute resolution. But in reality, it's usually the neutral, the mediator, the arbitrator, kind of raising the issue of combination. As I mentioned, it's very brave, and you need to have really integrity to do it, and gravitas as a neutral to do it, but it happens. And of course, the parties will decide on it, but you raise the issue. The institution, what I mean here, the institution is a dispute resolution service provider. In your word, I know the institution means something different, but I think we can make some analogy here. The institution has an awareness raising role. The institution itself would not kind of do it, but assessing the situation, understanding the dispute, raise the awareness that combined procedures is something to think about, right from the beginning or at some point in the dispute resolution process. Very important, who should decide on it? Always the parties, at least in the business commercial dispute resolution setting. Otherwise, we have a huge problems with the outcome. As like closing remarks, just very briefly, I think why there are many discussions on combination of procedures and unfortunately not as much practice. So we talk more about it than we do it. Is that there is a new attitude in dispute resolution, new expectation of the parties and different stakeholders. Nowadays, we can say that there are more practical expectations and demand parties, and most parties demand more and would like to have more efficiency, right? So cost, time on the one hand, one outcome and consequences. But on the other hand, it's very important. Talking about dispute resolution, that we need to keep balance between efficiency. We hope that combining procedures would gain and result in some efficiency for us. On the other hand, to keep the balance between parties' expectation to present their case, to have the opportunity to be heard, and to in general, to understand the background and to reflect on past issues. So sometimes we need to be past-oriented and we need adjudication and final decisions. What's most important, and I think the flexible sequences can be a huge asset in this sense, to find the appropriate dispute resolution. So you need to assess the situation first and then figure out which is the most appropriate dispute resolution process in a concrete case, and to be brave enough to change your mind. Maybe from the outset, you saw that this is only for arbitration, for adjudication, but to be flexible. Not only the sequences should be flexible, but our attitude also, that there is a moment that we can move on from, even from a very outcome focused to a rather collaborative process. In this sense, I would say to change our mind and to have a satisfaction both for the parties and of course for the neutrals. Thank you very much, and thank you for your attention.
Thank you, Manuela, for providing this very rich overview on flexible sequencing options. As you've highlighted, both the availability of various things that we consider in both the sequencing as well as the role that different parties can play in handling a dispute. I'd like to now hand it over to Paco, who will allow us to look at this in the perspective of a member of the Graham community.
So first I want to say that I hadn't met Manuela when I was when we were dealing with the case, and to me it was when we were reflecting on the experience of doing parallel process, those like the findings or like the lessons that we had learned were just how to say, non-professional lessons, or not filtered through the lens of an expert. So you would say it would be very interesting to then have a discussion, maybe not now, but in another day on another question, to how this experience relates to what Manuela has presented. I will limit my presentation to the description of the procedural aspects of this case. And also I will then maybe like conclude with some takeaways and positive and negatives, challenges and potential lessons. This was a very complex case. It was a case that dealt with matters of indigenous and Afro-descendant peoples' rights. And like factors for complexity, amongst others, were that there was extreme retaliation risks, not only risk, but also alleged events of severe retaliation or serious retaliation in a highly politicized context, and with allegations of severe human rights violations in a highly fragile program area, and with a complaint impacting the strategic international agenda of the country. In addition, there were multi-parties in all sides of the case. So that contributed to the complexity of the case. The compliance report, looking at the timeline, was submitted to the board. It was submitted to the board the last week of August in 2021. And since then, as Peter mentioned, the board still needs to decide on it. The complaint was received in June and declared eligible in July 2021. Following eligibility, we initiated what at the IRM called the initial steps phase, which is this phase where parties must choose between problem solving and compliance. And in general, parties showed a preference to try problem solving. In evaluating that choice, probably they foresaw that the report could face challenges when reaching the board level, amongst other factors. However, even when mediation was the preferred choice, they immediately encountered difficulties agreeing on the topics for discussion during the mediation, on building an agenda for mediation. They initially agreed on 4 agenda topics, but they struggled to agree on a 5th one, or to say. I could place that 5th one as a first one, because one party deemed this topic as essential and also conditional to accepting to participate in the mediation. Another important challenge was the governance and decision-making process. So both parties needed quite some time, sometimes 3 to 4 weeks, before responding to a request, positioning themselves on a particular issue, etc. So this is why we keep on extending the initial steps. Also because there was a mission travel plan, and it had been postponed several times due to several reasons. So because at the end of the 3rd extension, it was clear that parties could not agree on that debated agenda topic, the case was transferred to compliance. Nevertheless, soon after it was transferred to compliance, the IRM offered the parties to keep trying mediation, not mediation process, but talking about mediation or discussing the possibility of mediation in parallel with the compliance review process. Parties accepted that proposal. And quite surprisingly, right after resuming mediation in parallel to compliance, a solution from them was proposed to overcome the disagreement on the debated and conditional agenda topics. One party proposed a solution, the other one accepted it, but it was not a simple solution, because the final inclusion of the topic in the mediation agenda required procuring an external expert and delivering an impartial assessment on whether that topic could be linked to the project and therefore discussed during the mediation talks. Also, we noted a very significant improvement in how quickly the parties reacted to proposals, questions, and comments coming from the IRM problem-solving team. Probably not enough, but definitely quicker than before. So I think that it could be said that running the compliance review in parallel had as a first consequence the revitalization of the mediation process. However, meanwhile, the compliance review was also making progress at a very rapid pace. The instruction on how these 2 processes would interact with each other was the following. If parties could agree on all the topics to be included in problem solving, then the compliance review would be suspended. this idea of having the envelope or keeping the decision on the drawer. The idea was that even if the compliance review would reach its end with findings and recommendations, those would not be circulated to the parties or made public until the mediation had a chance to resolve the complex matters at hand. Consequently, with this instruction, if the compliance review reached its end and no agreement on the agenda topics of problem solving had been reached by that time, then the compliance review report would be issued and problem solving attempts would end. So basically, the idea was that whichever process reached a predefined milestone, that would end or suspend the other process. At the end, what happened is that the compliance review was making progress at a much greater pace than problem solving. The RM compliance team worked on the case nonstop for several months, including weekends, holidays, etc. And in turn, the problem solving process depended on getting responses from all the parties who were multi-party and needed significant time to collectively decide on things. So once the delivery of the final compliance report was approaching, although the problem-solving process had also made progress, in my view, I mean, this is my personal assessment of the situations, complainants were no longer interested in this resolution, probably because in their assessment, it was clear to them that the compliance review would favor them, their views. So next slide, please. As for the potential benefits or like identified benefits of this experience, compared to sequence processing, parallel processing of problem solving and compliance dramatically shorten the overall delivery of an outcome to the complainant. 14 months after the complainant had been declared eligible, a compliance report was issued. And not only that, options for a mediated solution also were thoroughly explored. Compared to sequence processing, the impression is that parallel processing also increased the leverage of complainants, or let's say the interest of both parties to try to resolve the issue. In our case, we noted that once complaints was launched and mediation talks were resumed, parties increased the energy and creativity they were put into finding creative solutions to their disagreements. Next slide, please. As for the challenges and potentially negative or like downsides, while the time to deliver an outcome halved as compared to a sequence process, the costs doubled. In cases where mediation comes before compliance and mediation succeeds in reaching an outcome, costs are limited to the mediation process. That was not our case. Another big concern was whether parties would understand the different dynamics of both processes. Would they still see problem solving as a safe space for them, even when they were participating in two processes of completely different nature and at the same time? I can say that in our case, my perception is that the answer was yes. They understood the differences and reacted differently to the both processes. But in our case, all parties were highly professional, highly sophisticated, and experienced to understand those different natures and dynamics. That might not be the case in all situations. Finally, next slide, please. On the lessons learned, or better say, things to reflect. Some things to reflect. One first question would be, in the case of parallel processing, should there be any coordination between both processes? If compliance reaches its end with a compliance report, and this is put in the drawer or in an envelope until mediation has proven to make progress, who decides that problem solving is showing progress? The head of the mechanism, or the parties might decide jointly on whether they are making progress or not. So here the risk lies in that the mechanism can be perceived as favoring one process over the other. Second, in any case, in parallel processing, mediation must also have sufficient time to deliver results. The increased pressure on the mediation process carries some clear benefits, at least in this case, but it should also not be such, the pressure should not be such that it undercuts the possibilities of mediation to deliver results. So here the question is how the added pressure or the added incentive is beneficial versus how much it is detrimental to the mediation process. Who makes the call on that question? Another takeaway is that in parallel processing, as it is the case in sequence processing, procedural questions should be answered at the outset of the process. Having either a clear agreement upon these procedural aspects from the parties or having clear procedures, it is definitely better than making decisions on the fly. And then my final conclusion, and this is a conclusion that is specifically targeted to the mediators in the room, is that sometimes, in my view, allowing compliance to start running in parallel to mediation is the only way some complainants will accept engaging in mediation. This is the case, for instance, when distrust between parties is so extreme that even including a trusted mediator isn't enough to ensure minimal trust. Or it could also be the case when complainants perceive mediation, like when it is sequenced at the beginning, as a trap, allowing their counterparts to postpone or eternalize the problem. In these cases, launching compliance can provide reassurance to complainants that engaging in mediation is not undermining their right to get an impartial review of their complaint. And that ends my presentation, Peter.
Thank you, Paco, for this overview on how the IRM's parallel processing has worked. I think we are running a little low on time. We have 30 minutes left, so we'll jump straight into our panel discussion with both David and Scott. We'll dive deeper into the applicability of these flexible approaches, especially as they can relate to grievance redress and accountability mechanisms. So let me first start by asking both of you a question of what do GRAMs need to keep in mind when considering different approaches, some that have been highlighted thus far by our two previous presentations, when handling complaints. So maybe we'll start with David.
Yeah, thanks so much, Peter. And thanks very much, first of all, to the IRM for hosting, to Manuela for great presentation, Paco, really interesting case. And we have an audience of colleagues here who I think Scott and I really want to hear from, so I think we're both going to go pretty short. But let me just say a few considerations. I want to say a little thing about some distinctions between the commercial context and the GRAM context, and then actually make a reinforcing case that, yeah, more flexibility and creativity around these options could be useful. And then I think Scott has some really interesting things to say about the way practice is actually evolving. So just to acknowledge that while there are very interesting parallels, there are also some important distinctions here from the commercial side around purpose, process, and power. So it's in a commercial context, we've got, you know, an adjudicator in an arbitration context or a mediator who's ultimately the servant of the parties. In the GRAM community, we have these institutional mechanisms that do have a responsibility to the institution as much as they do to the client and the complainant in a particular case. And again, normally we're talking about DFIs, IFIs that are dealing with cases in which there is a client or a recipient of funds that is having a conflict about implementation with a stakeholder on the ground. And so the institution may be implicated, but it's not such a simple thing as having a mediator or arbitrator fully accountable to the parties. Here, the institution's requirements are also very pertinent to the operation of the process. And then in the context of purpose, just to stress that institutional accountability is part of the mandate. And so arbitration in a commercial context is meant to make findings of fact and judgments about responsibility, tort, basically liability, and then make awards. In an institutional context, there is in the compliance track a sense in which the compliance track's fundamental question is, what's the institution's responsibility here? So it's actually a third party along with the client and the complainant. The second thing I just want to note about process is that the fascinating combinations that Manuela offered of mediation and arbitration are super interesting and I think very thought-provoking and ought to actually spur some creativity. I think it is important to note that the compliance process here is has a whole apparatus that involves investigations around institutional accountability that may actually not even be the primary interest of the complainant, but the complainant may see the need to clarify institutional accountability as a way to gain leverage on the client through the institution, then saying, because we are accountable, we will now follow up with the client and try to make remedial action possible. Footnote, longer conversation for another time, the issue of remedy remains a puzzle. And then finally on power, just to note that in broad brush terms, in the Graham community, these mechanisms are meant in some sense to provide some power balancing between the institution and the client on the one hand, generally more empowered stakeholders, and those on the receiving end or believing themselves to be on the receiving end of environmental and social impacts or human rights abuses. And so it's important to note that there is beyond a basic due process idea that all parties should have kind of equitable opportunities for participation, there is a tilt in the way these mechanisms are designed to ensure access and voice and some empowerment to the complainant. So I am not saying these things to dismiss the relevance of the commercial context and the cases the examples that Manuela has raised, only to just note that it is pretty important to keep some of those distinctions in mind. But then getting to the main thing, which is the possibility for more creative hybridization of compliance and dispute resolution, I think this is really interesting territory. And in particular, I would just note two things. One, even within the dispute resolution context, there are opportunities sometimes for independent fact-finding that has a quasi-adjudicative function. Scott may want to touch on the Nicaragua sugar case. In a US context, we actually used independent experts in an adversarial kind of hearing format to resolve questions about pollution runoff from a sugar plantation in Florida. Lest you draw the conclusion that arbitration is only useful in the context of sugar, there are, of course, many other examples of using independent fact-finding in the context of dispute resolution to settle some issues that then create space for mediation based on that now settled understanding of what happened and who's responsible, but now we mediate what to do about it. And that has some strong parallels to the Arb-Mead example that Manuela offered. Even within the context of thinking of compliance as a form of arbitration, and I think Scott will speak more to this, clearly there are some interesting things happening at the front end and at the back end around early action, suspending compliance, and at the back end around mediation of compliance implementation after a management report. I just think my bottom line here is that I think this community can think more creatively about ways to integrate the value and maximize the value of mediating and arbitrating forms of intervention. I think that Paco's case is a very interesting one of thinking about the ways in which having a compliance track run in parallel can incentivize the parties, but also provide closure. I have to think more about that case. There are some interesting questions there, but suffice it to say, I think it's very interesting. And I guess I would just, raise up for further discussion how do we need to balance the goals of complainant or party choice, institutional accountability, process efficiency, because depending on where we lean on those three things, it may take us in different directions with regard to how much flexibility we offer and the ways in which that flexibility between compliance and dispute resolution plays out. So I'll stop there again with thanks to the presenters and over to Scott. Thanks.
Thank you, and I'm conflicted. I really want to get to questions, so let me try to be as concise as possible. First, thank you to the hosts, to the Graham Partnership, Paco, Peter, for inviting me, for hosting us for this opportunity. I've been a previous participant at some of the Graham Partnership webinars. It's a privilege to be able to be part of a panel this time. And let me just get the quick formal disclaimer out of the way, and that anything I say is not actually or implied policy stance of the World Bank accountability mechanism. These are just things, in my capacity as a long-term dispute resolution professional, just some things for everyone to consider as we look at these questions. Which brings us back to Peter's question of what are some things we need to consider? And frankly, I think Paco and Manuela covered so much and made so many good points. I might draw out or highlight a couple of things I think worthwhile that they mentioned that would really answer that question in part. First of all, I have to say that, obviously the institution context matters. What are the current policies that you have? For example, at the World Bank accountability mechanism, as of today, the way our board resolutions are written, we are sequential. And so, how much flexibility do we have under current policy versus, what might mechanisms want to do in the future in tweaking their policies? So there's a policy question. And then even within your policies, if you've got some flexibility options, then there's still practical questions to decide. A lot of the questions that Paco, Manuela, and even David raised about, the timing, who decides, and all of these kinds of things. I think another thing to consider is going back to one of Paco's very first points, which was, sort of conventional wisdom that, forgive me, I'm paraphrasing, but if you want redress, you go to mediation. If you want institutional learning or precedent or policy change, you go to compliance. I think that maybe deserves its own webinar, but I think there's some nuance there that we could peel back, and I would guess that some compliance colleagues would like to talk about how redress could be achieved through compliance, either in reality or in theory if policies are strengthened. And likewise, I know on the dispute resolution side, we need to do a better job on the institutional learning, because I think there are opportunities there, and maybe we haven't always, fulfilled that as well as we could have. Manuela pointed out, I think, a really important point, which is, integrated is not the same as parallel process, because I think parallel is the general umbrella term that's used a lot in our world, and I think that was really important. And David, you picked up on this as well, that there's the kind of the institutional level and sequencing, whether it's mediation, arbitration, compliance, problem solving, et cetera. But then within dispute resolution, most of our mechanisms do have a lot of flexibility there by design. And so we don't have time, obviously, today, but there are some case examples, and these are in the public record. One I worked on in Uganda many years ago, around a hydro project where we were in mediation, but the parties agreed to have a subset of issues that would go to a medical arbitration board. And that was agreed by the parties. The mechanism didn't do the arbitration, but there was an agreed body that did handle those claims. Likewise, in Mongolia, there was a joint fact-finding process around impacts from a mine through a mediation process. Lots of technical findings. These were experts jointly hired by the parties, the terms of reference jointly drafted by the parties. And there are one of the recommendations of many, it's a 100+ page report. The experts did make some findings around compliance with a particular IFC environmental and social standard. But that was, again, within the context of a mediation and to inform some responses around what to do, in particular around land acquisition and resettlement. I think the other thing that Manuela highlighted that I would say people should consider when they're weighing these options are those pros and cons lists. I think a lot of what was in her summary would definitely apply to our world and things to consider there as well. Raising awareness, I think doing more things like we're doing with today's webinar, so that particularly when there are policy decisions or changes to be made, these are informed decisions. It's hard enough for those of us, these are complex issues. Those of us who do it day in and day out, there's a lot of nuance here. You can imagine when it gets to the board level with people who do not specialize in this work, helping them to understand the implications of the policy decisions they're making before they're made and set in stone. I think in the interest of time, let me leave it there. There's a few other points I could make, but I really want to get to questions so we can maybe respond to some things that are most value and interest to the participants.